You are. This is Dr. Olu Asekun again. Apology that we were not able to go live in the last couple of weeks due to other commitments and schedule conflict. But here we are today. Today we'll be discussing actions that can make you lose your green card. Actions that can make you lose your green card. Please post the topic. Okay, actions that can make you lose your green card.
Or jeopardize your green card application too.
Well, it will be a series. So today we are talking about actions that can make you lose your green card. Maybe next week we can talk about actions that can prevent you from getting your green card.
Okay.
And then upper week we can talk about actions that can make you lose ability to become a US citizen. So there are three different things. So today we are talking about actions that can make you lose your green card. So today we are addressing people who are already permanent residents, people who already have green card. So what are those things that you can do to make you lose that green card? That is the topic we are discussing today. In the meantime, can you please, let me see so that I will know when there are questions, please. Yes. So remember to invite your friends, family, colleagues to join us live. This is every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. 1 p.m. Eastern Time. Currently 6 p.m. Nigerian time and 10 a.m. Pacific time. So remember to join us. As I said, we are discussing actions that can make you lose your green card, assuming you already have one. So, from the name of the green card is usually called permanent resident. So, there is a presumption that once you have it, you can live here permanently. Yes, that is a presumption. However, there are some actions that can actually make you lose your green card, despite the fact that you live here. What are those actions? Number one, if you stay out of the US for more than 1 year at a stretch and you did not apply for travel permit before leaving, there is a presumption that you abandon your permanent residence. So, on your return, the CBP officer may deny you entry. However, let me say this, because you are already a permanent resident, they are not going to send you back to the country you are coming from. They will detain you and place you in removal proceedings where they will charge you as an arriving alien, having abandoned your permanent residence. However, like I said, it's a mere presumption. You can overcome this presumption. For example, you can show evidence, documentary evidence, to show that you did not intend to abandon your permanent residence by showing that maybe you have your family here. Let's say you travel alone, your family are still here, you have your primary residence here, you still pay your taxes, your family is working here, you maintain a bank account here, everything about you here remain ongoing. So there is no evidence that you actually abandon it. Maybe you have stayed extended period outside the US out of your control. Probably you fell sick and something. But if you are going to present something like that, you need to come with the medical report to show. Maybe you develop some illness and then the doctor say you are not fit to be in the plane to travel. So all those reports, you must come with it and present evidence that you did not intend to abandon your permanent residence. So if you are able to overcome the presumption, yes, you will be allowed in. But if you are not able to overcome the presumption, you may be denied admission and then they place you in removal proceedings. That is one. Two, what can make you lose your green card? Criminal activities. Now, since I think 1998, when IIRA, Illegal Immigration Reform Act, was passed, Since that time, the law, Immigration and Nationality Act, has actually increased the definition of aggravated felony. So many things that were considered petty are now considered aggravated felony. Let me say this: immigration law is very, very complex. There are several things that ordinarily will not be considered a felony. Even there are offenses in different states under state law that are not considered felony, but for immigration purpose, they are considered felony. It does not matter whether you are actually sent to jail. It could be mere probation. For example, under immigration law right now, I do know that DWI may be a felony for immigration purpose. Um, Theft may be a felony for immigration purpose. Domestic violence may be a felony for immigration purpose. All these things under state law, it may not be a felony. It may be mere misdemeanor under state law. But for immigration purpose, it does not matter. Immigration tends to look at the element of the offense and bring it under federal immigration law. It does not matter what the state did. In fact, in some cases, pre-trial diversionary programs where you are not even where you are not even where you did not even go into trial can still be considered felony under immigration law, especially where such pre-diversionary programs requires you to plead guilty. For example, maybe you are charged with DWI, and maybe the criminal defense attorney told you, you know what, go and do this defensive driving course, go and do this alcohol program, and then you come back, they file a motion to dismiss, and the court dismiss the case. For as long as that plea arrangement involves you pleading guilty for immigration purpose, that will be a felony. That will be aggravated felony for immigration purpose, and you can still be deported because of that, except you are qualified for a waiver. So offenses, criminal offenses may actually prevent you from keeping your green card. 3, another offense, and this one is extremely strict when it comes to immigration law, and that is drug offense. Drug or controlled substance offenses. Immigration law is extremely, and when I use the word extremely, I'm not using it lightly, extremely, extremely strict when it comes to drug offenses or controlled substance offenses. Generally, under immigration law, anyone who is convicted of drug or controlled substances, especially maybe marijuana, where the size is at least 30 grams, it is a permanent ground of inadmissibility. There is no waiver for it. There is no waiver. So even it doesn't matter who you marry, it doesn't matter what you do after, it doesn't matter what you did before, it is inadmissible ground. If you already have the green card, you will be deported. That is the law. There is no way around it. The only exception is where the size is less than 30 grams for personal use. Because even if the size is less than 30 grams, and if it is for commercial purpose, there will still be no waiver. You will still be deported. But where the weight is less than 30 grams, 30 grams, and it is for personal use, then if you have a qualifying relative who is a US citizen, parent, spouse, or minor children, you may still be able to apply for a waiver if you are able to show that removing you from the United States will create extreme unusual hardship to your qualifying relative. I've seen people convicted of 0 0.02 ounces, which is a fraction of 30 grams, and they were still deported. I've seen people convicted of 0.04 ounces, again, a fraction of 30 grams, and they were still deported. In fact, I've seen people with 0.04 with qualifying relatives, and they were still deported because they were not eligible for a waiver. The waiver issue is another thing. That's another complicated area of law. So it is not every permanent resident who has a U.S. citizen qualifying relative or U.S. citizen parents, spouses, or children that are eligible for a waiver. It is not everybody. So that is another complicated issue that I don't intend to go into now. I believe we've dealt with waiver before. If not, we will do it again. But the point is, the best way to keep your green card is to avoid criminal activities. It's as simple as that. It's as simple as that. I see that. Oh, I think I. Okay, I think questions have started coming in. Okay, the first question. I accidentally skip applying to remove condition on my green card and just apply for citizenship. Will I lose my green card for this? Can I fix this? There are two questions in this question, and both of them, the answer to both of them are yes. Yes, you can lose your green card because of this, but can you fix it? Yes, you can fix it. Because the thing is, because you are not a full permanent resident yet, because you are a conditional permanent resident, so once you did not apply to remove your condition, immigration is obligated to place you in removal proceedings. So yes, you can lose your green card because you will be on your way out of the country. You will be in removal proceedings. But can you still fix it? Yes. If you still remain married to the U.S. citizen petitioner, when they place you in removal proceedings, you can still go there and now properly file your removal of condition application, file it with USCS, obtain the receipt, resubmit it with immigration court, and then show to the court that your marriage is legit, which is the purpose of removal of condition in the first place. So you may still be able to fix it, but again, time and diligence is the key here. But can you lose your green card? Yes, you can, because of that. And of course, your citizenship application is also going to be denied. The next question. I heard that failing to file taxes for several years can make me lose my green card. Is this true? No, this is not true. Let me say this. Becoming a citizen and having a green card, they are two separate things. So if you have a green card and you don't file your taxes, you don't lose your green card because of that. However, if you apply for citizenship, you will not be eligible. Your application will be denied. Secondly, if for any reason you find yourself in trouble, in immigration trouble, you will not be able to apply for any relief that requires you to prove good moral character, because now you will be found to lack good moral character for not paying your taxes. So he has a lot of problems, and of course, more importantly, you could also be charged for tax evasion, which is a crime, is a federal crime. So all those things can happen, and of course, if you are charged with tax evasion and you are eventually convicted, that is an aggravated felony, and that can lead to you eventually losing your green card. So that is the only way you can lose your green card. The next question. I got a letter saying that USCI says I obtained my green card through fraud. So they are going to resign it, but it's just a notice. What can I do? Well, this is not a kind of question we can answer on this case because every case is different. I don't know the details. So it's not, I can't tell you what to do without knowing the details. So, but one thing is this: when somebody is in removal proceedings, it is different from when somebody is in what is called recession proceedings. Rescission proceedings and removal proceedings are not the same thing. So if you are placed in rescission proceedings, what that means is that the immigration court will determine whether you obtain your green card by fraud or not. That is the only thing. So even if the court concluded that you obtain your green card by fraud, they will not order you removed because that is not the purpose. However, if immigration obtain that information, if they obtain that judgment where the immigration court rule that you actually obtain your green card by fraud, thereafter immigration may now choose to place you in removal proceedings. And if they do that, God help you, because at this time they have already established that the green card was obtained by fraud. And because of the impact of section 204C, which says that anyone who obtain green card by fraud, no petition should be approved for such a person, that becomes problematic. So even if you remarry, you may not be able to fix the problem. And of course, having stayed here for a long time, being a permanent resident, that also means you are not even eligible for asylum. So you may be out of luck. That may eventually lead you to removal proceeding, to being ordered removed. Because even if you have been here for 10 years and you are eligible for cancellation of removal, the fact still remains that one of the requirements of cancellation of removal is to prove that you are a person of good moral character. And because immigration court has already made the determination that you obtain your green card by fraud, proving good moral character may be a challenge. It is possible you may be able to, but it will be a challenge. Next question. Sir, what options are that are available for someone with a student visa but not attending school because of finances? Unfortunately, this is not the topic for today. Today, we are discussing the issue of people losing their green card. I'm sure we have different podcasts on. Go and check our previous videos. We have discussed student visa extensively. There are videos on student visa. And if you don't find your answer, send a message. We will readdress student visa. But today, we are discussing how people can lose their green card. The reason we have to stick to topic is because whenever people click on our video to listen to the message and the topic must correlate. So we cannot post a video and say we are discussing green card, and then in the video people are listening to student question. That is not the purpose. That would defeat the entire purpose. So today we are discussing how people can lose their green card. That is the topic for today. The next question. My green card was rescinded due to USCIS investigation. They determined 204C. Can this be fixed? Well, as I said earlier, 204C is a permanent bar to any future petition, especially family-based petition, or any petition at all, because the section of the law says no petition shall be approved. It didn't say no family-based petition or no employment-based petition or no special petition. It says no petition. So it covers every form of petition. However, Does this mean that you will be removed? No, you may still be able to have other other relief depending on your peculiar circumstances. You may be eligible for other relief. It may be challenging, but you may be eligible. But generally, when there is a 204C finding, my advice to people is always to challenge it. Don't accept it. Don't just keep quiet and let it go. Don't challenge it, especially if you have evidence, because the Board of Immigration Appeal, the BIA, has ruled that before immigration can conclude that somebody has entered into a fraudulent marriage, they must have substantial and probative evidence on record. So you have to challenge it. Don't just admit it, because the moment you admit it, that is it. That's the end of the story. But you may still be able to challenge it, and you may still be able to have a other way out. But every case is different. There are no two cases that are the same. So I can't tell you, whoever sent this question, I can't tell you whether in your own particular case you may be able to fix it without knowing, having additional information. But generally, if there is a finding of 204C, you need to challenge it. And if you challenge it unsuccessfully, then your options will be limited, but you may still have other options. Next question. I got my green card approved through my employer. I'm no longer working for the same company. Can they take the green card away from me? No, 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 no. Once you are a green card holder, you are a green card holder. It doesn't matter who your employer is, who sponsor you. In fact, even before the green card is approved, if you have been if your application has been pending for up to 180 days, you can actually change employer without any problem. And again, once your green card is approved, you are a permanent resident. You are a permanent resident. You are not under bondage. You don't have to work for the same employer, and there is nothing the employer can do. Even if they write a petition to immigration that you left, the petition will not carry any effect for as long as you didn't commit a crime. The next question: what is 237A1H? Well, 237A1H is a form of waiver that is available for permanent residents. Permanent residents who obtain their green card by fraud. That is what 237A1H waiver is. However, like I said, whether you are eligible for 237A1H waiver depends on individual case. It is not a blanket. It's not a blanket thing. So it is on a case by case basis. Somebody may obtain their green card by fraud and still be eligible for 237A1H waiver. Somebody may also obtain their green card by fraud, apply for 237A1H waiver, and the court may deny it. So it is not, it depends on the fact of each particular case, and it depends on the level of evidence the government have against you. But of course, 237A1H waiver simply is a waiver that is available for people who already have green card but obtain it by fraud. The next question: I'm a petitioner. My spouse received his green card, but I just found out he has been cheating on me. Can I have his green card taken away? Well, cheating is not one of the grounds to take green card away. The only thing is, if you can prove that your marriage with him was not legit, then the green card may be taken away. But for you to do that, you will also be in trouble, because that also means that you also committed fraud on the government. That also means that you also perpetrated fraud on USCIS. And if you go back to look at Form I-130, petition for alien relative, that you filed on his behalf, if you look at page 9 of that form, you will see that as a petitioner, you will be fined $250,000 or sentenced to 5 years in prison for knowingly engaging in a marriage contract. So if you allege that the marriage is fraud because you are the petitioner, it means that you also committed fraud. But other than that, there is no way his green card can be taken away. uh, Cheating on you, well, unfortunately, it's a problem, but it's a moral problem. It's not a legal problem. And I can tell you that even the immigration officer that is going to adjudicate your case, what is the guarantee that he is not cheating? So cheating is not a is I mean, I'm sure if you have been living in this country, you will see even politicians who cheat on their spouses. I remember, was it last year, there was this politician who took who went to a different country to go and meet another woman. I mean, people cheat from time to time. It's not that is not ground to take away green card. No, it is not. The only ground to take it away is if it was obtained by fraud. That can be taken away. But again, in this particular case, you yourself will be in trouble because you are the petitioner, and it means that you perpetrated fraud. Of course, if you admit to your fraud, you cannot be deported because you are a US citizen. He will be deported, but you may end up in jail as well. The next question: I have a temporary green card, but I'm no longer together with my spouse. Will I lose my green card? This is not a yes or no answer. As I said, every case is different. In some cases, you may lose your green card. In some cases, you may not lose your green card. It depends on the exact fact of your case. It depends on the evidence that you have. If you are given a conditional green card, before your conditional green card can become a permanent green card, you are required, you and your petitioner, you are required to file a joint petition to remove condition. Now, if you are no longer together, if you can show that during the marriage, the petitioner was abusing you, was cruel to you, and you have all the evidence, and that is why you left the marriage, the green card can still be approved. Secondly, if you can show that at the time you enter into the marriage, you enter into the marriage in good faith, but the marriage just didn't work. The law does not require that a marriage must work. What the law requires is that the marriage must have been entered into in good faith. So all you need to do is to show that although the marriage didn't work, it was entered into in good faith, and you can go ahead and apply to remove condition alone. But you must have substantial evidence that your marriage was entered into in good faith. And of course, this type of application will require an interview. So they will interview you and ask questions. And in some cases, they may investigate your story or your evidence. But it doesn't necessarily mean that that is the end of the green card. No, you may still be able to apply a loan. The next question: if USCIS resign my green card, am I automatically deported? No, I just answered that question previously. Rescission proceedings is different from removal proceedings. So if all that happened is that USCIS sent you a letter telling you that your green card has been rescinded, that is all it is. It is just that letter. You are not automatically removed. Because for immigration to remove you, they still have to place you in removal proceedings, and they will issue NTA, notice to appear, and the notice to appear will have the allegations against you, and of course you will have the opportunity to defend yourself in court or even ask for any other relief. However, if immigration placed you in rescission proceedings, you will not have the benefit of presenting any other relief. The only benefit you will have is to defend that particular marriage, to show that your marriage was entered into in good faith, or whatever, because or whatever fraud that immigration is alleging to overcome that ground of fraud. That is what rescission proceedings is all about. However, if after the rescission proceeding, if the immigration court found that your green card was actually obtained by fraud, they can't do anything. But immigration can subsequently place you in removal proceedings. This is when you can now be ordered removed. Rescission proceedings does not lead to removal. It is removal proceedings that leads to removal. The next question. My mom is a permanent resident, but she just told me that she voted in the last election, 2020. Could she lose her green card? No. If she's already a permanent resident, she's already a permanent resident. However, she will not be able to she may not become a US citizen, because voting in an election is a disqualification for US citizenship. She may be able to keep her green card, but she may not be able to become a US citizen. The next question. How long can I stay outside the United States without risking abandonment of my green card? Less than 1 year. If you stay out of the US for less than 1 year, you are not going to risk the abandonment of your green card. But at the same time, you may not be able to apply for US citizenship, because US citizenship requires physical presence in the US. So if you are planning to become a US citizen, you cannot stay out of the US for 6 months at a stretch. But for abandoning your permanent residence, you have to stay out of the US for at least 1 year and more. The next question. Does frequent travel to and from the United States raise any concern regarding my green card? Yes, depending on the CBP officer. Legally, frequent travel, does it affect your green card? No, for as long as you don't stay out of the US for more than 1 year. However, I've seen a situation where some CBP officers, they look at you and say that you apply for permanent resident, but you are not living here. You stay out of the US all the time, and they can raise an issue. However, let me tell you this: no matter how rogue the officer is, they cannot revoke your green card. They cannot take your green card away for as long as you have not stayed out of the US for 1 year or more. But can they delay you at the port of entry? Yes, they can delay you. They can ask you questions. They can do all of those things, but they cannot take your green card away on that ground. And let me say this, in order to avoid that, if you know that you are a frequent traveler, just apply for travel documents. Just apply. There is a passport that USCIS will issue to you, and travel with that passport and your green card. No matter, even if you travel every week, nobody will raise any issue for as long as you have that passport. Next question. Are there any traffic or civil violations that could negatively affect my status? Oh yes. Oh yes. Especially where traffic offenses led to arrest. Remember that traffic offenses are usually citation. Now, if you are issued a citation and then you decide to abandon it, you decide not to take it seriously, and then the period that you are supposed to respond to it have passed, the period you are supposed to appear in court, you didn't show up, the period you are supposed to pay fine, you didn't pay it. Now maybe they decided to issue a warrant of arrest. Depending on a lot of other factors, yes, it can become an issue. A simple traffic stop can lead to a major trouble. So it depends on how you handle it. But the traffic stop by itself, the traffic offense by itself is not a problem. But how you handle it can eventually lead to major problem. The next question: can using public benefits such as Medicaid or food stamp put my green card at risk under public charge rule? No. These are issues before you get your green card. They are not issues after you obtain your green card. They are before. They are issues before. They are problematic before, not after. The next question: I have missed a lot of discussions today. Oh, that's just a comment. Well, you can go back and listen to the video after. The next question: can working abroad for a US company or a foreign employer affect my residency status? Well, this is not a yes or no answer because it depends on the detail. As the politicians always say, the devil is in the details. You may be working for a US employer outside the US and it may not affect your green card, but it depends on the status of that employer. Is it an employer who has national security importance? Is it an employer that has substantial US interest? Let's say Mobile USA, for example, or what's this? What's the name of this airplane manufacturer? Boeing. Let's say Boeing. Yes, those kind of companies, if you work for them outside of the US, it will not affect your green card. Also, if you are working for a US non-profit religious organization outside of the US and you are on a mission, it will not affect your green card. And of course, if you are working for the US government or an agency of government outside the US, all those things will not affect your green card. So it depends on the peculiar situation. But let's say myself and Olu Asekun, let's say I have a company called XYZ company. I register that company in South Africa and I post you to South Africa to go and work. You will lose your green card if you stay out of the country for 1 year because my company is not a US security national interest or US government or government agency, and it's not a non-profit of the US. So those kind of things will affect your green card. So that's why I said the devil is in the details, as the politicians say. The next question: are there actions I should avoid if I plan to apply for citizenship in the future? Oh yes, but I think we are discussing the issue of citizenship later, so I'm not going to go into that now. Right now, we are discussing the issue of what you can do to lose your green card. So next week, we are going to discuss what you can do to prevent you from becoming a US citizen. So we'll deal with that. The next question: what happens if I forget to renew my green card? Can I lose my status? No, you can't lose your status if you forget to renew your green card. The only thing, you will not be able to travel out of the US. And of course, if your employer requires evidence of your green card, especially if you want to apply for a new job, that may also be difficult. But do you lose your status? No. Green card itself is evidence of status. It is not the status itself. The status itself is the permanent resident status. So it is like being a driver. You learn how to drive, you go through learners permit, you learn how to drive, and you apply for driver license. Your driver license is valid for 5 years. If at the end of the 5 years you don't renew it, does that mean you no longer know how to drive? No, you still know how to drive, but you will not have evidence that you are authorized to drive, which is the purpose of driver license. It is exactly the same thing with green card. Green card, the card itself is evidence of your permanent resident. It is not the permanent resident. Your status is the permanent resident status. So if you don't renew it, the only problem is you will not be able to show evidence that you are a permanent resident, but legally you still remain a permanent resident. In fact, you may apply for citizenship without renewing it. You may choose to apply for citizenship if you are already eligible without renewing it. So that tells you it is not the card itself that determines your status. The card is only evidence of your status. The next question: are there any political activities or affiliations that could jeopardize my green card status? Oh yes, any organization that is designated by the US government as a terrorist organization, it doesn't matter the time you join, and it doesn't matter whether you have left. If you are a member of a particular organization, even when you join, if that organization was not designated as a terrorist organization, if the organization is subsequently designated as a terrorist organization, yes, it can affect your green card. It may affect your green card. The next question: I was riding in my friend's car and he was pulled over. There were drugs in the car. I didn't know, and I was arrested too. If convicted, could I lose my green card? If you are already a permanent resident and you are not yet a citizen, if you are convicted, yes, you may lose your green card, but it depends on the weight of the drug, and it also depends on whether you are eligible for a waiver or not. But the thing is, for as long as you are convicted of drug offenses or controlled substance offenses that the weight is more than 30 grams, it is a removable offense. It doesn't matter whether you are the one who put it in the car or not. That is evidence you have to present at the criminal court so that you are not convicted. So if you don't know anything about it, your only chance of not being removed is to fight it in court. When they charge you to court, do everything you can to fight it, to show that you didn't know anything about it. That is your opportunity. But if you are convicted, you cannot put up any evidence at the immigration court to say that you didn't know anything about it, because immigration court will not re-adjudicate your criminal conviction. That is not their role. So you have the opportunity to fight it when you are still facing criminal charges. But after conviction, the only thing you can do is to go back to appeal the conviction or consult with post conviction attorneys and try your luck to overcome it. But for as long as the conviction stands, there is nothing you can do with immigration. It is a deportable offense if the weight of the drug, of the controlled substance, is 30 grams or more. The next question: can participating in protests, rallies, or other civil activities have immigration consequences? No, for as long as there is no conviction. I mean, if the rally is declared illegal and you are arrested and prosecuted and convicted, yes, it may have immigration consequences. But in a country like the US, it is very unlikely that anyone will be prosecuted for protesting. But again, protest, people do all kinds of things under the guise of protest. Sometimes people protest and then they break into stores, they steal things. If you engage in that and you are caught, yeah, that's a criminal activity. Even though the what you are doing was protest, but because of the protest you committed an offense. Yes, if you are convicted, that may turn out to affect your green card. So it is not the protest itself, it is the activities that it is the criminal activities that will lead to problem with your green card, not the protest by itself. Next question. If I am ever arrested, should I contact an immigration attorney in addition to a criminal lawyer? That is the best advice. However, in many criminal courts, the US Supreme Court in Padilla and Kentucky states that for any non-citizen who enter into a plea bargain, the court and the criminal defense attorney must explain the immigration consequence of that plea to that person before the court sign off, before the judge sign off on that plea bargain. So that is the issue. But generally, a lot of criminal defense attorneys, they are not familiar with immigration consequences, so they may not even know. Most of the time, their own concern is to ensure that this person does not go to jail. That is why they will give you programs that, oh, you know what, just plead guilty, we place you on 10-month probation, and then after that the case will be dismissed and everything will be clear from your record. That may be true as far as immigration, as far as criminal court is concerned, but that same thing can still be classified as aggravated felony for immigration purpose, and you can still be deported because of that for immigration purpose even after you finish your probation. So immigration has its own peculiar requirement, and that is why it is advisable that when you hire a criminal defense attorney, if you are not a US citizen, you need to ensure that an immigration attorney is consulted, especially if you are going to plead guilty, so that you know the consequence of your action before you take it. You take an informed decision. Okay, the next question. Can a CBP officer force you to surrender your green card? Force. I don't understand the question. Why would they force you? Can they take your green card? Yes, if they have reasons to.
They force you to sign on the, when you're giving up your residence card.
I-407. Like, is there any way that they could like push you to like sign the I-407 to relinquish your
Nobody can force you to do anything. Nobody. Remember, immigration law, immigration offense, immigration violation, these are different from criminal violations. So nobody can force you to do anything. Can they trick you? Yes. If there are if there are rogue officers, yes, they can trick you. They can lie to you. They can tell you things that are not true. They can, yes, they can trick you. That is the word.
During COVID time, they were at the border, they were handing out these forms to people, specifically the ones that were crossing the border by land. And so they were telling them that if they were going to Mexico or maybe Canada, that they should sign up on that. Like, sign those
Yeah, they can trick you, yes. But force you, no, they cannot force you. But they can trick you.
Mhm.
The next question. Do I need to disclose foreign assets or accounts to the US government, and how could failing to do so impact my status? Oh yes, if you are a legal permanent resident, you are required to declare your foreign assets when you file your taxes. And of course, if you don't disclose it, if they don't know, good luck. But if they found out, you may be in trouble, especially in tax trouble. As far as immigration status, It is only if there is any criminal conviction that it will affect your immigration status. So if the IRS goes after you and then charge you for an offense, prosecute you and found you guilty, convict you, then it can affect your immigration status from that standpoint. The next question: if I lose my permanent residence based on criminal record, can I ever apply for it again? Yes, in very limited circumstances, especially where the offense is not an aggravated felony. Very limited circumstances, yes. The next question: are there any specific business activities that could lead to the loss of my green card? I don't understand what this question means. Specific business activities. Do you understand the question?
Like remember what do you call those businesses that sell CBD?
Oh, like
That is still controlled substance. That comes. All those ones comes under controlled substance.
So, yeah.
I've already I answered that in the past. If you get involved in controlled substance, because
So
the drug, yes, you know that immigration is a federal law. It is not a state law. In some states, marijuana, for example, is legal in some states. But for as long as it is not legal federally, so if you sell CBD or something and you get convicted for it, maybe in another state or by the federal government, yes, it will affect your green card, because it is the federal law that applies when it comes to immigration, not state law. So if it is legal in the state, it is immaterial.
The state law will only apply in a criminal case.
In a criminal case
when
in the state, in the criminal case in the state court, because it will not even apply in a criminal case in a federal court. It is only a criminal case in a state court.
Legal status,
That is federal. So it is the federal law that will apply. So that falls under controlled substance. So if you are going to do a business involving drugs, CBD or anything, find out what is the position of the federal law on it, especially if you are not yet a US citizen. The next question: if I need medical treatment outside the US for an extended period, how can I maintain my green card? I've answered this in the past. Just apply for travel documents. Tell immigration that you intend to travel out of the US for an extended period. So apply for travel document. They will give you a passport. That passport will say USCIS, issued by USCIS. So you use that passport together with your green card. So you can stay out of the US for years, even up to 5 years, no problem.
So now remember, this passport is normally given to permanent residents for up to 2 years, I believe.
No, you have to choose the timeline.
Yes,
so when you apply, they will ask you. So if you request 2 years, they will give you 2 years. If you request 5 years, they will give you 5 years. And if you request 1 year, they will give you 1 year.
Okay, so let's say this person needs treatment, and this person was told that the treatment will only be for about a year or so, over 2 years. But then it goes beyond there. So what can this person do, since the person is outside of the country? What can this person do if that passport
they will need to contact the US embassy in that country and apply for what is called SB1.
Okay.
SB1 in order to return to the US.
Okay.
I don't know if the listeners had your question. So
right. Yeah.
Okay.
Yes,
Okay. Okay. The next question: I'm a green card holder and I donate to different organizations. If it comes out later that one of these organizations is a front for a terrorist organization, could I lose my green card? Oh, yes. This is a capital yes. Those are the things that American government detests. And remember, there is a money laundering law. So in fact, based on this fact, this is exactly what is called money laundering. Somebody using a front to receive donation, and then that donation eventually gets into terrorist organization. That is money laundering. That is a criminal activity. Yes, I can guarantee this person, he will lose the green card.
Even if they just donated and they didn't know.
He will lose the green card. I can guarantee you that.
Yeah.
And remember, when it comes to terrorism, there is no waiver.
Oh yeah.
There's no waiver. The next question. If I join the military of another country, could this affect my green card? No, for as long as you don't stay out of the green card. It doesn't matter. Remember that green card holders are not US citizens. You are still a citizen of your country. So you are still loyal to your country. You just live here. You are not a citizen. That's why they don't ask green card application. That's why they don't ask about oath of allegiance, because they know you are still loyal to your country. The only thing is that you live here. So it doesn't matter. You can join the military in your country. That's your country. You are not an American. So why should it be American government problem? The next question. What are the consequences of applying for or accepting a government job in a foreign country while holding a US green card? When you say government job, I believe this person is talking of US government job.
No. Like foreign government job.
There is no, it doesn't have any consequence except that it is just about you not staying out of the country for 1 year or more. That's it. It doesn't have any consequence. Like I said, you are not a US citizen, so they are not expecting you to be loyal to the US. You are not a citizen, so
So when you
you.
apply for citizenship, that's when they will question
If even then, when you apply for citizenship, they will question you. The only question is, are you willing to now be loyal? Are you willing to forego what is it that you ever do or you ever have? For example, even mere having a title of nobility is against American Constitution. But if you are a green card holder, that's your choice. If you choose to become king in Syria, you become King Syria. That's your problem. It doesn't affect American government. But when you apply for citizenship, they will ask you, you know you have this title, and our own country does not allow it. Are you willing to forego, to renounce this thing? So it is at that stage that your loyalty becomes an issue. But before, it doesn't matter. The next question. Good day, sir. What can someone who has been out of status for a long time but residing in the US do to ensure he or she is back to status? Well, unfortunately, this is not the question we are discussing today. Today, we are discussing how someone who already have green card can lose their green card. That is the topic today. I I will advise whoever sent this question to go back to our previous videos and check any video that is related to this. Otherwise, maybe when we revisit this topic, we can do it. The reason we always like to stick to the topic is because whenever we title a video, when people click on it, we want them to see that it is that title that we are discussing. We don't want to say that we are discussing somebody losing green card, and then when people click on the video, they see that we are having discussion about religious activities. No, that will not be good enough. I want you to understand that what we are trying to do here, we know that because of time schedule, because of schedule conflict, everybody cannot be live to watch this program live. Some people go back later to watch it. So when they are scrolling the videos, when they see a title they are interested in, they click on that title, and we want to ensure that the title we give them is what they see, not that we give a title and we'll be discussing E. That would not be fair. So, and I believe it is already past 1 o'clock. Oh, do we have additional questions? Okay. What happens to my minor children's green card if I lose mine or if I move abroad? Well, if you move together, I believe that whatever happened to yours will happen to theirs, because it means that all of you will have spent more than the required time out of the US. However, if you left them behind in the US and you travel alone, nothing happened to their own status. They keep their own, and they can eventually become citizens and probably refile for you. So it doesn't affect yours. But if all of you travel out together, then the same way you have stayed out of the country for extended period, they too would have done the same thing. So the same law will affect both of you. Okay, I believe that today will be pausing on this topic. Again, we'll continue this series next week, and I believe next week we are discussing what you can do to prevent you, what can prevent you from becoming a US citizen. So we hope you join us again next week. Remember to invite your family, friends, and colleagues. Until then, see you. Have a blessed day.